come before the Court of Chips and Bank United.
Morning.
Well, I guess we're after. Well, whatever it is. Anyway, each side will have 15 minutes for argument. The appellant may reserve up to 5 minutes. You may proceed.
May it please the court, my name is Grace Doverdracht, and along with my co-counsel Mark Dan, we're representing appellant Charlene Chips. And I'd like to reserve 5 minutes for rebuttal, please. This case was previously on appeal before this court in Bank United versus Klug. And in the previous decision, the court found there was a material issue of fact regarding whether Bank United's loss of priority was due to its own actions. The trial court abused its discretion in adopting the magistrate's decision that found that equitable subrogation applied because equitable subrogation is not allowed if the loss of priority was due to Bank United's own actions. So there's several key facts in this case that would show that the loss of priority was in fact due to Bank United's actions. First, Carey Klug applied for a loan, filled out the uniform residential loan application in April. While they say that he failed to disclose his marital status, it's not that he said he was unmarried. There was no box checked at all. And at the transcript of the hearing, Eric Darmanin testified that in that type of situation, if there's no marital status filled in, that they would try to clarify and find out what the marital status for the homeowner was. The actual mortgage that was prepared and sent out to Carey Klug said Carey Klug, a married man. So at some point, Bank United must have been on notice that he was married, and they prepared a mortgage for a married man. Now at the actual, the mortgage that was signed has typed X's over the married man, and it says, comma, an unmarried man. And that's initial, but the notary testified that he did not make those changes, and that Carey Klug did not make those changes.
He being who?
The notary. He testified that he did not use a typewriter to X out a married man. And Bank United had testified that they prepared a mortgage for a married man. The loan application that was signed on the day of the closing checks the box for married as Carey Klug's marital status. So if Bank United prepared a mortgage for a married man and they got back a mortgage that had a married man X'd out, it was their job to do their due diligence and find out what happened at this closing or prior to the closing if they in fact weren't involved in those changes at all. Before they loaned $1 million to Carey Klug, they should have asked, why are the mortgage documents different than what we had prepared? And the notary's testimony was that he did not make those changes, and Carey Klug did not make those changes. So somebody else had to alter that mortgage document. And that was something that the court previously looked at in the Court of Appeals where they said there was a factual issue. Was the alteration to the mortgage something that Bank United could have been involved in? Was the loss of priority the result of their own actions? Because Charlene Chips was married to Carey Klug at the time this mortgage was executed. And in Ohio, that means Charlene Chips has a dower interest in the property. And under Ohio law, even if Carey Klug had purchased the property prior to them being married, she still has a dower interest. And
Does she still have a dower interest hypothetically if they get divorced?
divorce is the way to cut it off, Your Honor. But they are currently married right now. And they were married at the time it was executed. Under Ohio Revised Code Section 2103.02, the spouse would have to release the dower interest. And usually that's done by having the spouse sign the mortgage. In this case, appellant Charlene Chips never signed the mortgage. And she wasn't involved in any other way in this particular loan. And one of the other things that occurred in the previous appeal regarding whether there should be an equitable mortgage on Charlene Chips' dower interest, the Court of Appeals found that there was no evidence that Charlene Chips had done anything to warrant the imposition of an equitable lien on her interest. So when the case was remanded back to the trial court and the hearing was held, there was still no evidence presented that Charlene Chips did anything that should involve her losing the priority of her dower interest. Because she was married to Carey Klug prior to this mortgage being executed, her dower interest should be higher in priority than Bank United's mortgage. And that's not what the magistrate found. And by making the finding that her dower interest was junior in priority to the mortgage, that also affected the magistrate's decisions related to the dower calculation, by saying that she should only be entitled to the surplus from foreclosure sale. Where there's a number of cases cited in the brief that show, in a case where the spouse didn't sign the mortgage, that her interest should be first in priority, and that it should be paid from the total market value of the property. And in this case, this property is appraised by the auditor at over $2 million. One of the other issues that led to the magistrate's decision is that she improperly relied on the testimony of Eric Darmanin that the April loan application, where there was no marital status, is what Bank United relied on. There's a couple problems with that. One, Eric Darmanin was not a corporate representative. It was stated at trial that he was not testifying as a corporate representative of Bank United. So if he's not testifying as a corporate representative, he can't speak for what Bank United relied on. And he was only involved in the case post-litigation, so he would have no personal knowledge of what they actually relied on. The second problem with saying that they relied on the April loan application is that it has the wrong loan amount and the wrong interest rate. So if that's what they relied on, how did the actual mortgage that was issued have the identical loan amount and interest rate that's on the June application? The June 23rd application was signed by Carey Klug at closing, but there's a date at the bottom where it looks like Keith Kennedy filled this out and completed it on May 23rd, about a month prior. So it would make sense that Keith Kennedy filled this out, the box is checked for married, that was submitted to Bank United. Bank United then prepared a mortgage that said a married man. They sent it out for it to get signed. Carey Klug's testimony was that there were 2 times that somebody appeared at the property. The first time they came, and because they didn't get Charlene Chips' signature, the mortgage didn't get signed. Then Carey Klug's testimony was that he was told by the mortgage broker that Bank United wanted him to execute this mortgage as an unmarried man because when he originally took out the loan, he was unmarried. And during this time period, there was a statutory warranty deed that was prepared. And this deed is from Carey Klug, no marital status, to Carey Klug, an unmarried man. And that was put in the packet of things for Carey Klug to execute at the loan closing. If you look at the settlement statement, you'll see that the settlement statement dated June 22nd, they refer to a charge for this document to be recorded as part of the closing. And Carey Klug hadn't even signed it in front of the notary until June 23rd. So there's no way that Bank United can claim that they didn't know that this deed was being executed, or they weren't involved somewhat in the execution. Whether they actually drafted it themselves, or they had the title company draft it, it's on the closing statement, and it was part of the packet. And there's no reason to do an execution of a statutory warranty deed from him with no marital status to an unmarried marital status. If he was unmarried, he could have simply signed the mortgage as him being unmarried. There was no need to execute a deed. The other problem with the execution of this deed is that it doesn't list the current marital status for Carey Klug. So the person who drafted it didn't put in a marital status form at the time he was executing it to himself as an unmarried man. And if you look at who they say that it should be reported on, who requested the recording, you'll see that it was part of the title, First American Title Insurance Company, which is the same title insurance company on the closing documents. But this charge is on the settlement statement, and Mark Mays, the notary, testified that he gave all the documents at the closing to Bank United. So Bank United received this statutory warranty deed. Again, before they loaned over $1 million, they should have asked, what is this deed? Why does he have this deed saying that he's unmarried when we fill out a mortgage that he was married? And they could have simply called Carey Klug. But there's no testimony that before dispersing the funds, they called Carey Klug and he told them that he was unmarried. That's not in the record anywhere. So there's no indication that they relied on any statement from Carey Klug in order to disperse this money. And Carey Klug's testimony is that he told the mortgage broker, and they got the application signed the day of closing where it's checked that he's married. So, looking at these other things in the case, Bank United takes the risk that if Carey Klug is in fact married, they didn't release Charlie and Chip's dower interest, and that's what happened in this case. It turned out that he was married. They could have simply verified this by checking the probate records, not necessarily in Lorain County, but across the state, you can find marriage licenses in the probate court records. And they could have done a simple search to just say, we'll check on this ourselves. We could have asked Carey Klug, or we can just do the search ourselves and find out if he is in fact married. But by not doing their due diligence, by being negligent, by not being informed about the property, they made the mistake and took the risk that if he was married, they didn't release her dower interest. And that's what happened. And I've cited the case in Wells Fargo.
Counsel, you're in for rebuttal if you want to say that.
I'll say this. I cited Wells Fargo versus Mowry, that the mortgage can't be reformed if there's excusable negligence. And that's kind of what they're trying to do with this equitable mortgage, is just say, let's just act like Charlie and Chip signed it, even though she really didn't. And again, the case City Mortgage versus Brown, where the husband had in fact signed the mortgage and released dower, because he had an ownership interest, the court said, we're not going to find that he mortgaged his interest. There's no reason to impose an equitable lien, because that's not what the parties intended when they signed it, and the bank was negligent, and it's the same type of situation.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Russell Cutel. I'm with the law firm Frost Brown Todd, and we represent Bank United in this case. Your Honors, this case should have been a relatively simple mortgage foreclosure case that was commenced more than 6 years ago. And it should have been over a long time ago. We're here because of one reason and one reason alone. There were fraudulent misrepresentations made on one of the documents was actually a federal mortgage about a marital status. As a result of Mr. Klug's execution of 2 documents at a closing in which he fraudulently misrepresented his marital status, we are here today on 2 separate issues. The first issue is whether or not Bank United's mortgage should have priority over Ms. Chips's dower interest. And the second issue, which hasn't been discussed yet by the appellant, is what number should be calculated, or should be multiplied, by a dower factor to calculate Ms. Chips's dower interest. It's important to also note, by the way, that the actual dower factor is not on appeal in this case, so that's not an issue before the court. The only question is what number should be multiplied by that dower factor at this point in time. As the appellant has readily acknowledged, the standard of review on these issues is an abuse of discretion. I'm not going to bore the panel here with the standard. I'm sure everyone's aware. In this case, they would need to show that the trial court acted unreasonably. And in this case, after one evidentiary hearing and one oral argument, the evidentiary hearing was on the priority issue, and the oral argument was on the calculation of dower, it is very clear that the trial court based both of its decisions on case law existing here in the state of Ohio. When you take a look at the issue of equitable subrogation, and I don't think the appellants are disagreeing, equitable subrogation is still an equitable doctrine that is readily accepted still here in the state of Ohio. The Ohio Supreme Court back in 2010 in the ABN AMRO versus Kanga case acknowledged that equitable subrogation still exists in the appropriate factual circumstance. In that particular case itself, due to the facts of that particular case, the Ohio Supreme Court felt that equitable subrogation should not apply with those facts. However, the doctrine itself still exists here in Ohio. Would the court like a discussion of equitable subrogation itself, or?
That's completely up to you.
Okay. Equitable subrogation, the way it works is when there is a loan which is secured by a mortgage, and it is used to pay off a prior mortgage loan, with the understanding that the new mortgage is supposed to have a first priority interest. The new mortgage lender can step into the shoes of the old mortgage lender whose loan was released if there are issues, defects in the mortgage itself. In this case, it was the court, again, conducted an evidentiary hearing on the issue of the mortgage priority. Because I will readily submit to the court, if there was culpable negligence, then there are cases that state that equitable subrogation does not apply. However, I'd like to bring this to the court's attention. It's not precedential, but it is, I think, persuasive. There's another case that we have cited to in our briefs. It's called the Lorain Larson case. It's an Eastern District of Wisconsin case where the facts are identical. In that case, the borrower, just like Mr. Klug here, took out a loan before they were married. They then subsequently get married, and then after that, they then take out another loan to refinance the first loan. In that case, the wife did not execute the new mortgage.
Did she know about the new mortgage?
In that case, she knew about it, and actually in this case too, Ms. Chips knew about this refinancing. In fact, she said the only reason she didn't execute the loan documents was she did not want to be obligated on the note. That was in her deposition as well as at the hearing, the evidentiary hearing. In that case, in the Lorain Larson case, it's a bankruptcy court case. They filed for bankruptcy, both of them. The trustee tries to get the mortgage released, claiming that it doesn't encumber a somewhat equivalent principle of homestead interest in Wisconsin. It's a similar interest to the dower interest here in Ohio. At the end of the day, the court looked to the question of who was at fault. Was the lender at fault, or was the borrower at fault? Not the spouse, but the borrower. And in that case, they determined that the borrower was at fault for failing to disclose their true marital status, which is exactly what Mr. Klug did in this case. Bank United properly prepared a mortgage stating a married person. They then that was presented to Mr. Klug at closing. However, at closing, at some point in time at closing, and before the mortgage was returned to Bank United, the typed in language by Bank United, a married man, was crossed out, and on top of it was typed in a single man. Not only was that typed in, and there is nothing in the record that shows who typed it in other than Bank United stated they did not type it in, but on top of it being typed in, Mr. Klug initialed it in handwriting right next to it. He fraudulently executed a federal mortgage document. On top of that, a statutory warranty deed was also executed at closing. The only testimony in this case is that Bank United did not prepare that deed. There is nothing in the record whatsoever as to who prepared it, but we do know Bank United did not prepare it. Now, there was supposition in the beginning of this oral argument as to why that would be done, or it shouldn't have been done. And I would submit to the court that that is not the case. In any mortgage transaction, when a chain of title does not contain a marital status, it is customary, regardless of whether or not the person who owns the property is single or married, to make sure that the chain of title is clean as to what their marital status is. For this very reason that we are still, 6 years later, arguing, is there a dower interest that needs to be dealt with? Mr. Klug executed a statutory warranty deed, which was notarized as well, stating that he was a single person when he had been married to Mrs. Klug for almost a year at the time. As the court is again aware, the standard here is abuse of discretion. The trial court, after conducting a full evidentiary hearing, actually went for a full day, determined after testing the credibility of the witnesses that Mr. Klug, this is a quote, Mr. Klug, not Bank United, was the best person to know whether or not he was married in 2006. Despite knowing that he was married in 2006, Mr. Klug executed Bank United's mortgage with the words "a married man" crossed out, thereby representing that Mr. Klug was in fact not a married man. Furthermore, Mr. Klug signed a statutory warranty deed on June 22, 2006, granting to himself as Carey Klug an unmarried man. The court went on further to state the only two people who could say for a certainty that Mr. Klug was actually married in 2006 were Ms. Chips and Mr. Klug. the court clearly dealt with this issue of whether or not there was culpable negligence, and found that there was not. Additionally, the court went on to say Bank United's representative stated that had Bank United known that Mr. Klug was married, it would have either required Ms. Chips to sign the mortgage, or if she refused, would not have issued that 2006 loan. The trial court clearly acted reasonably in looking at the existing case law and determining there wasn't culpable negligence and that equitable subrogation should apply. And taking some language that came from the In re Larson case that I previously discussed, to allow Mr. Klug and Ms. Chips now to benefit from Mr. Klug's own misrepresentation would only serve to encourage borrowers to conceal the existence of a spouse when a debt is refinanced. Contrary to Ms. Chips, there is no finding of wrongdoing at all. There may be supposition by them, but there is nothing in the record showing any wrongdoing by Bank United. And all of Ms. Chips' supporting cases are inapposite. There's no evidence whatsoever of any negligence on the part of the lender. Now, when we go to equitable mortgage, the fact is we don't even need to get to the doctrine of equitable mortgage with equitable subrogation applying, but the trial court did. And again, it looked to case law and determined that due to the wrongdoing of Mr. Klug, there should be, even if equitable subrogation were not to apply, there should still be an equitable mortgage there that has priority over Ms. Chips' dower interest. Again, not precedential, readily admitted, but persuasive. We cite to a case Palm Beach Savings and Loan versus Fishbein. Again, this case is exactly factually on point. You have a husband and wife who had prior mortgages that had been properly executed. That's called one fact that is not exactly on point, but there were mortgages that were properly executed of record. Mr. Fishbein in that case takes out another loan during a dissolution or divorce proceeding with his wife, Mrs. Fishbein, and forges her signature. She knows nothing about this new loan whatsoever. The new loan gets financed with the forged signature of Mrs. Fishbein, and later she tries to get it unraveled. And the court stated there that the plaintiff has clearly shown fraud on the part of Mr. Fishbein in obtaining the loan, although no fraud by Mrs. Fishbein has been shown. I find that the lender should have an equitable lien on the property to the extent that its loan proceeds were used to pay the pre-existing mortgage. The reason why the Florida Supreme Court affirmed that decision and found equitable mortgage is that the feeling was, although Mrs. Fishbein knew nothing about the wrongdoing, they felt that she should not be entitled to, in this case, a $930,000 windfall. The homestead exemption is intended to be a shield, not a sword. No one is arguing that Ms. Chips is not entitled to a dower interest. The only issue here is, should it have priority over Bank United's mortgage? A mortgage, which was, at the time, a $1,050,000 mortgage that had been used to pay off a prior $1 million mortgage that Bank United gave to Mr. Klug before he was married to Ms. Chips, a loan that Ms. Chips knew existed the day she got married. She knew she already had her dower interest. The day she got married was second in line to a $1 million mortgage loan. So Bank United submits that the trial court acted reasonably in finding both equitable mortgage as well as equitable subrogation. Now there's arguments here that the court abused its discretion in relying upon the testimony of Mr. Darmanin. First of all, this argument can be dealt with very readily because the credibility and the knowledge of Mr. Darmanin was never objected to during the magistrate's evidentiary hearing. Never. There was not one objection there. And in fact, his testimony was relied upon by Ms. Chips in subsequent briefing. Secondly, not only was his testimony not objected to at the magistrate's evidentiary hearing, it was also not one of the objections that was raised to the trial court after the magistrate rendered her decision. For both of those reasons, the case law is clear that that argument itself has been waived. But even if Your Honors are going to look to the substantive argument itself, the fact of the matter is Mr. Darmanin was a properly qualified witness to testify as to what he did. Mr. Darmanin had worked for Bank United's predecessor, who actually made the loan, for 6 years prior to the first loan having been made, and 7 years before the mortgage loan at issue here had been made. There was testimony that Mr. Darmanin actually, he knew the underwriting practices and procedures that were in place for the 2005 and 2006 mortgage loans that are involved in this case. Not only that, he also had testified, and it's in the record, that he had become aware of the loan and the mortgage itself through review of the business records of Bank United. The trial court even held, or stated during the evidentiary hearing, that Bank United had, quote, produced a witness, Mr. Darmanin, that can testify as to the documents that pertain to this matter for the court's purposes, that Bank United has complied in doing so. The trial court held, again, I think it was approximately 8-hour evidentiary hearing. There were several witnesses that were presented. The magistrate judged the credibility of the witnesses and found Mr. Darmanin obviously to be honest and trustworthy. As this court has previously stated, the determination of the weight to be given both to the evidence and the credibility of witnesses is a function primarily reserved for the trier of fact. The court here found that he had personal knowledge of what he had testified to and had properly testified. Finally, we go to the issue of the dower calculation itself. The trial court found that the dower factor, again, not in dispute in this case, should be, which is 3.70866%, should be multiplied by the foreclosure sale proceeds that remain pending after Bank United's loan is paid. The reason is that Bank United has priority over Ms. Chips's dower interest. The main support for that was the In re Rosario case, which Ms. Drobajak herself had said was the case that she led with in the oral argument in front of the magistrate. And it's true, that In re Rosario case says, depending upon the priority of the dower interest and the prior lien, and the lien, if you have a prior lien to the dower interest, you calculate, you first pay off the prior lien, and then you use the remaining foreclosure proceeds and multiply it by the dower factor.
Counsel, unfortunately, you're out of time.
Okay.
Thank you.
Thank you.
Your Honor, with regards to the dower calculation on lien priority, the N v. Rosario case dealt with the priority, and Appellant Charlene Chip's argument is because the previous magistrate's decision put her lower in priority, junior to Bank United, then the court had to apply the surplus at the foreclosure sale rule. But the argument is that Charlene Chip's is first in priority. So then if you look at the N v. Rosario case, she should be paid on the total market value. Her dower should be calculated at the total market value. To just briefly distinguish, there was a Palm savings case cited by Appellee. That case involved a forgery, and it also involved, previously there was a mortgage that was signed by the wife. Appellant Charlene Chips did not sign the mortgage in this case and did not sign the previous mortgage. And under the statute, Ohio Revised Code Section 2103.041, the dower is only subordinate to common creditors. Bank United is not a creditor of Charlene Chips. If they had her properly release her dower interest, then they could have claimed that her dower was subordinate to them, but they never had her release the interest, so she's still first in priority. There was no finding by the trial court that Carey Klug fraudulently misrepresented anything on his loan application. And there was culpable negligence on behalf of Bank United because there was this April application where there's no marital status. The testimony from Eric Darmanin was that Bank United would check, either by emailing or calling, to find out what, in fact, the marital status was. They prepared a mortgage that said a married man. So at some point, they must have had notice that Carey Klug was, in fact, married. And he was married. The loan application that they received at the closing had the box checked for married. The notary, Mark Mays, testified clearly that when he went out there, he did not type anything over the married man, and that Carey Klug did not alter that. So somebody had to change the document before it was given to the notary. And if Bank United did not make that change, they're negligent in not figuring out or questioning why the mortgage they prepared came back in an altered state. And so they would not be entitled to equitable subrogation. Equitable subrogation in courts across Ohio are usually used for other lien holders. Dower is not a lien. It's a possessory interest. And it could be improper to apply equitable subrogation when this isn't a lien and when Bank United's not a common creditor of Charlene Chips. The equitable mortgage wouldn't make sense to apply because we're not disputing that there's a valid mortgage between Carey, Klug, and Bank United. And that's the type of situation where courts would usually apply equitable mortgage. If some issue happened regarding Carey, Klug, and the execution. But the issue in this case is that Charlene Chips never signed, and they never had her sign. And that was their mistake and their risk, that if she was married to Carey Klug, which she was, that her dower interest would be first in priority. And the purpose of dower is to protect the spouse. And the case Deutsche Bank versus Smith that's cited in our brief says that there's no action by one spouse that could take away the dower interest of the other spouse. And that's when the magistrate erred in finding that Carey Klug was in the best position to know whether they were married, and pretty much putting the blame on him. The case law is clear that there's no action of one spouse that can take away the dower interest. So anything that occurred with the loan closing, there was no evidence presented that Charlene Chips did anything wrong. And this court in the previous appeal said what would warrant imposing the equitable lien. And Bank United did not present any evidence at the trial hearing to show that Charlene Chips took any action that would warrant. And she testified that she wasn't interested in signing the mortgage and she wouldn't have signed. And Bank United issued this loan. There's the statutory warranty deed that's prepared. It's on the closing statement. So they charged Mr. Klug for the preparation. This is part of the loan. And the error in relying on Eric Darman's testimony is that he says Bank United relied on the April application, but the April application does not have the right loan amount or the right interest rate.
And counsel, you're out.
I ask that you reverse.
Thank you. Thank you, both sides for your presentations, and the court will take the matter under advisement, issue a written opinion that will be sent to both sides, and also the court will release on our website, the Supreme Court website. So thank you very much. And the court is